Greetings to one and all present over here. This is Simren Srivastava, and I'm here to speak something about Article 17 of the Indian Constitution. Before delving deep into what Article 17 says, let's understand what untouchability is, the topic that Article 17 deals with. So, untouchability, talking in layman terms, we all know what it is. Untouchability is a practice of discriminating against a certain person on the basis of their caste. So, where did it originate from in India? Let's see the history. Starting from the Vedic period, there was no mention of caste system. The society was divided on the basis of Varna system. That was on the basis of what job a person does. And there was no mention of discrimination. As the time progressed and the society escalated into a later Vedic period, the period of Smritis, we see a slight mention of strict rules regarding these Varnas, but yet there was no mention of discrimination against any caste. So, where did this come from? It was the time when the Vedic period was ending and the medieval period was starting. The time when the Buddhism was on decline and Brahman supremacy was being established. Around the time of the pinnacle of the ninth century, it's safe to say that the mentions of discrimination on the basis of caste started from there. The evidence could be found in the blogs of Chinese travelers like Fa Yung. So, what exactly it is? The thing is, the concept of untouchability is discriminating against a person on the basis of what caste he belongs to. Now, caste is not something you could acquire or change during a lifetime. It's permanent. It comes with you from your birth and ends with you when you die, and it gets carried on in your blood. So, what are the discriminations one faces due to the caste? Some of them might be you cannot drink water from the community well, live outside the city, and many others to do measly jobs like killing animals and cleaning toilets. So, when India gained its independence from the British, the practice of untouchability was rampant. It was widespread and was practiced as second nature. Well, the Brahmins and the upper caste were compelled to discriminate against non Brahmins as a part of their culture, and the lower caste that discriminated against always felt impure and had an internalized sense of inferiority. So, what did our constitution make us do? Let's find out the ideas first. The two pioneers of abolishing untouchability from India were Mahatma Gandhi and B.R. Ambedkar. Mahatma Gandhi specifically said that it is a social evil in the society of India. He termed the word Harijan to denote many people who belong to the lower caste, and B.R. Ambedkar, the champion of the lower caste community, the founding one of the founding fathers of a constitution, the Constitution of India. So let's talk about Article 17 now. Article 17 reads that untouchability in any form is abolished and its practice is unconstitutional and a criminal offense. Now, the word in any form is a very inclusive term which is very beneficial for the lower caste people. They can report it as a violation of also the violation of the fundamental rights of Article 21, which guarantees a dignified life to every citizen of India. And there are many other provisions that correlate to this section and make state make laws for their betterment. For example, the subclause 4 of Article 15 that specifically directs the state to make laws for the betterment of scheduled caste and scheduled tribe, or the Article 334 which guarantees reservation in educational and job fields for the lower castes which were discriminated against. Now let's see some case laws. Some of the few we'll take two case laws. First would be where this article was implemented, and second where the constitutional validity of this article was challenged. So for the implementation part, we'll study Surya Narayan Chaudhary versus the state of Rajasthan. Now in this case, there was a temple that was discriminating against the lower caste people on the basis to enter. They were forced to go through purification process to enter that. So In a PIL under Article 17, the court of Rajasthan held that it was a violation of Article 17 and it was a form of discrimination. Hence, the temple was forced to let go this practice. Now, for the constitutional validity part, there's a landmark case, that is Jaising versus Union of India. In this case, the Supreme Court held that the discrimination for years amounts for some compensation and reservation in the field, and hence it was valid then. Currently, you would know today, that is today's date is the 11th of January 2025, the Supreme Court did ask the Parliament to revise the reservation policies so that the reverse discrimination doesn't start. In conclusion, I'd like to say that untouchability was a social evil big enough, and we should keep in mind what the previous generation did and learn from them, and try not to make an equal society and keep the spirit of preamble of India alive, justice for all, while we give everyone equality. Thank you.